India has officially put into force a fresh set of privacy rules, a major step that finally operationalizes Digital Personal Data Protection Act 8 years after the Supreme Court declared privacy a fundamental right. Let me explain what changes for you and for big tech. With almost 1 billion Indians online, the government says companies have been collecting far more data than necessary. So these new rules ensure less data collection, more user control, strong protection against leak. This is India's biggest privacy update since the landmark Puttaswamy judgment of 2017. So what can companies collect now? Only what's absolutely necessary. Apps and platforms must clearly explain why they need your data, how they will use it, for how long they will keep it. You can also opt out anytime. If your data leaks, companies can't stay silent anymore. They must notify affected users immediately, report the breach to the Data Protection Board within 72 hours, provide a detailed report on what went wrong. This is one of the strongest consumer protection clauses in the new law. Companies must now follow strict safeguards like encryption, access controls, logging mechanisms, internal audits. Plus, there's a key addition. They must retain all logs and personal data for at least 1 year after use to help with investigations. Platforms with huge user bases must now delete user data after 3 years of inactivity. It gives users 48-hour notice before deletion. And this applies to e-commerce companies, social media intermediaries with 20 million plus users, online gaming firms with 5 million plus users. There is special protection for children also. Processing a minor's data gets tougher now. Now, verifiable parental consent is mandatory. Consent must be verified using trusted ID documents or digital tokens. The goal is to prevent misuse of children's digital footprints. Can companies send data abroad? Yes, but with guardrails. India will allow cross-border data transfers except to countries or agencies the government flags as restricted. Importantly, the rules do not force companies to store all data inside India, which had been a long-running debate. But when do companies need to comply? Tech firms have 18 months from now until May 2027 for full compliance on data handling, retention, consent frameworks, child protection mechanisms, and breach notifications audits also. Experts claim that this is a reasonable window given the scale of changes that are required. India is also drafting new rules for AI companies with ChatGPT, Gemini, Perplexity. Having millions of Indian users, the privacy framework ensures less blind data extraction, clearer consent pathways, better accountability. Dhruv Garg of the Indian Governance and Policy Project calls it the most significant operational step since the DPDP Act became law in 2023. India's new privacy rules are inspired by the spirit of Europe GDPR but tailored for India's scale. This is not just about regulating big tech, it's about giving Indian users real control over their personal data for the first time. For more news and updates, stay tuned to FPG.